But no one who followed the proceedings of the Supreme Court will be surprised with the judgment pronounced a few hours ago. Much as I'm aware that we are legally bound by the decision of the highest court of the land, the Supreme Court of Ghana, I disagree with the process of the trial and the ruling of the court.
All right, it's here for for Mobi Biara Akwaba. Currently, there is an update. Updating and say what is happening, and debena ABC after the verdict which came from the Supreme Court, the highest courts of the land. Let me give you a quick turn of events and give you what is happening on the ground. I'll also be showing you videos along the way. Na enye kasankwa, so you can pick up whatever I'm saying from scratch. And then the Supreme Court. As a day, they will come out with their judgment. It's an panel between the hours of 8 going, they were live, they read paragraph. Their verdict was very long. Very long verdict. And they read it. Now, one thing I'm out for expecting, me I was expecting is definitely this case, encore in favor of NDC. I was hoping, say, in as much as encore in favor of NDC, at least we were by a best substantial, but and I said, Mahama, courts no koi no enquire kwa. But at the end of the day, the Supreme Court in its own verdict, they came out to say, after looking and cross-examining many witnesses, looking at the cases of the petitioner, the first respondent, the second respondent, and other matters arising concern this whole election and the jurisdiction, they've come to a conclusion that Mahama has no case, and as such, they dismiss it. Now, what Ghanaians were all expecting was, what is next? What will Mahama do? Menoka say in Wakasa. The video we showed you before this particular excerpt, and this particular Asama news we edit to that was a live video Mahama call live some few hours ago addressing the election petition. We'll be showing you a lengthy one in some Kenyan said he refuses to accept the verdict and as the outcome of the court. As a citizen, he has every right to say that, but he's bound by law. As the verdict came, said Akufo-Addo was the ultimate winner, and by law, Akufo-Addo is recognized as the president-elect and the president of the Republic of Ghana. And as such, that is what the Supreme Court has said. Mahama has tried his best, but that is where it is. But Mahama saying he's going to accept it or not, I believe say as a citizen has every right to agree or disagree. It is his right as a citizen. Now, this is what is happening. Mahama didn't seem be priatuja. As I said, I'll drop the video for you to see. But then, I'll just explain some few key points. Now, some few key points I'm explaining. We make video now to send they can follow exactly what is going on. Now, on your screens, a lengthy paragraph Mahama and the message this was about the election petition court case. Osha national address by His Excellency John Dramani Mahama. Me read it, I'll show you the video. But Osha in Sema Okawahan basically semi-quoting verbatim or parties the Supreme Court earlier today verdict or the buy and a verdict on the buy concerning the December 9th 2020 election. Or more parties said Madam Jem Mensah perhaps and was a case a command, and aside from that too he Mahama anticipated the case will actually be called for Madam Jem Mensah and the second respondent Nana Addo Dankwa, so they were not shocked at all. Now, show video of what John Dramani Mahama and some of the two, as you can see on your screens.
From the chairperson of the Electoral Commission as the returning officer of the December 2020 presidential elections. Ghanaians were hoping to hear her testify, and many are still baffled by the refusal of Mrs. Jem Mensah to be held to account by testifying in this case, unfortunately with the unanimous agreement of the justices of the Supreme Court. The vital part of the process to establish the truth and hold Mrs. Mensah accountable was blocked time and again by a protective cordon and firewall that I'm sure has confounded many Ghanaians. The refusal of this chairperson is in sharp contrast to the readiness with which Dr. Kwadwo Afarijan, then chairman of the Electoral Commission, willingly testified in the 2013 election petition filed by then candidate Nana Akufo-Addo of the MPP. Speaking as a Ghanaian with no legal training, I believe that the refusal of the Electoral Commission chairperson to testify in this election petition leaves a very bad precedent for the future. I disagree with the suggestions of our justices that an election petition is akin to any other civil litigation, and therefore an EC chairperson whose functions go to the heart of our democracy can, by a legal sleight of hand, avoid accounting for her stewardship in an appropriate forum such as the highest court of the land. Our legal team, led by Mr. Chachuchi Kata, put together our case in a clear manner. Which left no one in doubt about the issues that were at stake. Apart from seeking to ensure compliance with the Constitution and for the true choice of the people of Ghana to be respected, the petition sought to provide opportunity for transparency and accountability in the management of our electoral process. But no one who followed the proceedings of the Supreme Court will be surprised with the judgment pronounced a few hours ago. Much as I'm aware that we are legally bound by the decision of the highest court of the land, the Supreme Court of Ghana, I disagree with the process of the trial and the ruling of the court. For the avoidance of that, I say, much as I'm aware that we are legally bound by the decisions of the Supreme Court, I disagree with the process of the trial and the ruling of the court. Ladies and gentlemen, our 1992 Constitution says very directly in Article 125, Section 1, that justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. I believe that law should not be an instrument for partisan purposes. I also believe that the rule of law should mean one rule for all. What anchors the rule of law is equality and fairness to all, irrespective of creed, background, or political coloration. Justice, we must remember, is rooted in moral foundations. Ghanaians will always remember that moment when my lead counsel, Mr. Chachuchi Kata, quoted from the Holy Bible, urging the justices of the Supreme Court to be faithful to their judicial oath and their conscience, only for the lawyer representing the second respondent to argue for the exclusion of God in this matter. And yet in the courts of Ghana, including the Supreme Court, we swear on the Bible or the cross, as we also do with the Holy Quran, to speak the truth and nothing but the truth. Ghanaians will also remember, and this will go into history, this 2021 election petition for that profound moment when the chairperson of the Electoral Commission opted to evade public scrutiny. Everything was done in this trial to prevent the Commission from accounting to the people in whose name they hold office. Requests for interrogatories were dismissed. A request for inspection of documents in the possession of the Commission was turned down. The request for admission of facts was ignored. And worse still, she was aided by her counsel and the court to avoid explaining to the good people of Ghana from her own testimony under oath in a properly constituted court of law the errors that she herself admits to have committed in the declaration of the 2020 presidential election results. This is a clear stab in the heart of transparency and accountability to the sovereign people of Ghana. Whatever the reasons for not allowing Mrs. Jean Mensah to testify or answer any questions, it leaves an embarrassing stain not only on our justice delivery system, but also on our nation's electoral system, which has deepened the grave doubts harbored by many Ghanaians about the true outcome of the December 2020 presidential elections. Ladies and gentlemen, the motto of Ghana's Electoral Commission is transparency, fairness, and integrity. Principles that the key actors of the Electoral Commission clearly failed to live up to on this occasion. The refusal to account to Ghanaians further sets the worrying precedent, and I do really worry about this dangerous precedent that may allow other heads of state institutions to adopt an approach of opacity and non-accountability in their work, just because they know they can rely on unconvincing interpretations of our laws to shield them from scrutiny in the near future when they are held to account. I hope and pray that time will prove me wrong. There's a famous legal maxim brought into common use by Lord Chief Justice Hewart in 1924, that justice must not only be done, but should manifestly and undoubtedly be seen to be done. While judgment was given in this petition, it cannot be said by many to have been seen to be done by the constant unanimous strictures placed on the petitioner in laying out his case. I followed the proceedings of this petition and listened to the testimony of our General Secretary, Johnson Asiedu Nketia, from beginning to end. I'm quite alarmed at the mutilation of his testimony in the Supreme Court ruling. Indeed, the ruling I heard today virtually makes our witness, Johnson Asiedu Nketia, appear like the star witness of the first and second respondents. Many answers of his testimony in cross-examination were taken out of context to create the basis for the dismissal of our election petition. At the appropriate time, the legal team will come out with detailed comments on today's judgment. Ladies and gentlemen, this case will go into the Ghana Law Reports for the future, and academics and students of law alike will clearly find befuddling the internal contradictions in our jurisprudence. The Supreme Court has given its verdict, but the national debate on the dismal state of our democracy and the increasing weakness of our state institutions has only just begun. It is time we all come together to confront those who seek to destroy the very democratic system that brought them into office. It is our patriotic duty to do so. Ladies and gentlemen, it bears reiterating that our grievances with the conduct of the 2020 elections was not limited to just the presidential elections. Doubts about the Commission's commitment to fairness and transparency have lingered much longer than the duration of this petition. The doubts have attended their every action, and rightly so, because of their posturing and sometimes duplicitous conduct. As I've alluded to in the past, the current leadership of the Commission was installed after the politically motivated removal of the previous Commission. Since then, every step they have taken has appeared to be calculated at ensuring the return of the appointing authority in power. Aside from the compilation of a new register in the midst of a pandemic, one that many civil society organizations, political and governance experts insist was more procurement-minded than needs-based, the time-tested process of consultation and dialogue among stakeholders through the Inter-Party Advisory Committee was supplanted by unilateralism. This has not boded well for harmonious relationship with stakeholders. Compared to the two previous leaderships of the Commission, what we have now does not meet even the minimum requirement of neutrality and non-partisanship. And these are two essential principles for consolidating our democracy. Today, the much-touted independence of our Electoral Commission exists only in name. This should give all Ghanaians cause for worry. Today, we still have, as a member of the Commission,